govern talks about a nomination in which somebody nominates a suitable candidate, a fit and proper person, to be considered as a judicial appointment. And the nominee consents to that. So in the instant case, what took place was that Madam Justice Makhubele was nominated by somebody. She accepted the nomination in anticipation for being interviewed by the Judicial Service Commission, who then made a recommendation, which is then the second part, where the recommendation is made, and she is then, the President is required to appoint her in terms of Section 174, subsection 6. He doesn't have a choice. On that recommendation, he has to appoint Judge Makhubele as a judge. That's the law. And Section 174, subsection 8 prescribes that once a judicial officer has been appointed, as envisaged by Section 174, subsection 6, before that judicial officer can commence his or her duties, they are required to take the oath of office. And we had a lot of debate about at what point the oath, whether that was indicative or was required that the oath of office be taken. And Judge Mlambo was quite emphatic that the point at which a person is elevated is when the recommendation is then brings about an appointment and in this particular case, the appointment took place on the 2nd of November. So to equate the appointment of a judge with somebody who was going to be getting a job working as a prosecutor, for example, which I'm familiar with, there is an offer and acceptance which takes place. This doesn't happen in the scheme of things with judges. And in fact, my learned friends who appear on behalf of Unite Behind will more adequately deal with this question than I can. There is constitutional court authority to the effect, I believe it's the case of Van Rooyen, where the judge, where Shaskelson CJ said a judge is not an employee. I'm sure the two members of the tribunal who are judges would take some umbrage at the idea that they were just ordinary employees rather than judges of the High Court. But thank you for raising it, Judge Moshidi, because this is never raised before in this tribunal. That we are dealing with a case where Madam Justice Makhubele was offered employment and declined to be employed. It flies in the face of the evidence. The first response to the 19th of October, I accept the appointment. That's the 20th of October. Can we talk about when I'm going to start? And then what does one make, members of the tribunal, about the WhatsApp, the clamant WhatsApp of late March, where she tells the Judge President, I have resigned all my positions, I'm now unemployed, can I start? Now, how does that marry with somebody whose perception was that they had not been appointed as a judge? Why do you make that request in late March when you, according to you, you weren't a judge? She was a judge, and Judge Makhubele appreciated she was a judge. But yet, when the wheels fall off the wagon, so to speak, with her relationship with PRASA, she approached the judge president and said, I've resigned everything. I'm now without work. Can you please employ? And what was the judge president's response? He said, you can't start. We've got to sort this thing out with the minister. So that flies in the face of what the evidence has been, that there was an offer and an acceptance, quite apart from the legal consequences of it. Then, so I hope that answers your question, Judge Machine.
Okay, we'll hear later about it in more detail. Could I ask you, as you go on with your argument, just to indicate to us or to me on what page of your heads you are?
I will do so.
Because we make notes against these things when we receive them.
Thank you. I'll do so.
When you deal with the second count. Thank you very much.
Well, Judge Mashidi, can I direct your attention then to page 121, 121. Members of the tribunal, we reiterate the issue of, again, in respect of the second count, various witnesses testified and were cross-examined at some length, and pertinent and highly material disputes of fact which arose from the evidence of Judge Makhubele were never put to witnesses. And we refer, of course, to the locus classicus on the point, President of the Republic of South Africa versus SAFU, which is reported to be a judgment of the Constitutional Court. We make the respectful submission that it was clear that in the face of the evidence that was adduced in regard to count 2, or the second complaint, that the respondent, Judge Makhubele, must have sensed the difficulties posed to her by the evidence. And she sought to tailor her evidence to meet the challenges to an acceptance of her version. And we submit that by way of contrast to the evidence presented against her, Judge Makhubele tried to account for her involvement in the settlement of the CIA claims. And this consisted in simply denying the unchallenged evidence of witnesses and attributing the failure to challenging evidence to her erstwhile counsel, whom she claimed she had properly instructed. We submit with respect that this was not the truth. And we say, given the training and experience, it is hardly likely the respondent would have meekly abdicated and remained silent in the absence of her unequivocal version being put. In page 123, we deal with the respondent's version vis-a-vis Mr. Francois Botha's. Her version was that Botha had been the driving force in the settlement. He had contacted her first, a claim he denied. It was he who informed her that the CIA matters had been referred for arbitration. Botha testified it was she who had first raised the CIA matters, and the allegation was never challenged by her counsel. Her evidence was that it was she, his evidence was that it was she that had told him that she could not trust the internal and external lawyers, and this evidence was also not challenged by counsel acting on her behalf. He alerted her to what had happened in the insolvency inquiry, that PRASA witness had made concessions. She entertained a visit from Botha's when she received the report of Kricher and an email exchange between Botha's and Mogashwa. It is quite clear that Botha's clearly jumped at the opportunity to advance the interests of his clients. She continued, according to Botha's, to be in constant contact with him, either by way of calls, by way of SMSs, by way of WhatsApps. Curiously, she claims that despite her firm view that she did not expect of counsel to lie, she branded Botha as one who presented hearsay evidence and forged documents as manifested by the letter dated the 18th of March 2018 by Matopo to Bowman's, relying on messages sent by the respondent to Botha's and to the AGCO, the AGCO being the acting general CEO, group CEO. That was Mr. Maleko at the time. This she described as unethical behavior. She claimed that she distanced herself from him. She went so far as to say that he was abusing her. Firstly, that none of this was put to Botha by her counsel when he testified. To the contrary, during his cross-examination, there was an attempt to try to get him to give answers favorable to the respondent's case. Second, the very exchanges which the respondent relies on to bolster her case, namely those placed before the tribunal, I refer to Makhubele exhibits, the core volume 17, 176 to 184, and volume 1876 at SEC, reveal that the respondent had extensive communications with him long after she claimed to have distanced herself from him. And the tribunal, remember pressing her, when was that? And that was January 2018. However, even those aspects of the evidence which were not belatedly challenged paint a very different picture in our respectful submission of the extent of her involvement, and which show the falsity of her claim that it was not her decision to settle. The respondent testified that if she was the one who had ordered the settlement, why would she have left a paper trail? The answer to that question is simple. The paper trail, such as exists, was the product of her disregard of, and not little ignorance on her part of the proper processes which were to be required of her as chairperson at PRASA. That much was evidence from her ignorance of the powers conferred on the board according to the very delegation of authority which she had claimed all along was the one which was binding upon the board. The members of the tribunal will recall there were two delegations of authorities which were produced by Martha Ngoyi. The first one, that was the one that was applicable, which was called the Popo Malefu one. The second one, upon which Madam Justice Makhubele placed so much reliance, was the Buthelezi one, which had been replaced by the Popo Malefu one. Neither of the two delegations of authority gave the board the power to settle the four claims which were the subject of the summonses and which were settled. This behavior on the part, to want of a better word, on the part of Judge Makhubele as chairperson of PRASA is mirrored, we respectfully submit, by her in her demeanor when she testified and in her conduct towards the tribunal. She unfortunately presented as a truculent and sometimes unduly aggressive witness, particularly in response to questions by members of the tribunal which were put to maintain some semblance of relevance in these proceedings. At paragraph 142. The record of her evidence is replete with examples of the evasive failure of the evasive feature of her evidence. The respondent was not prepared to address any question posed by the tribunal with a simple, pithy reply when such a reply would have been sufficient. And I set forth 4 examples which indicate the point that I'm trying to make. I will not read those out. In her evidence, she testified. Let me see here, I've left, what can I say to you? The 4 attorneys. Now, this was a question Judge Mashidi asked her directly for her response. Can they lie? They lied because the talk about non-existence reports. They lie because they say non-existing concessions. Later in her evidence, the respondent testified, and I'm saying, taking it from here, it means that I must answer the question that was put to me, that why would these people lie against me? And I say there are reasons why they would lie against me. Firstly, we say that it is a clear misrepresentation of what the witnesses had testified to. The evidence was that they had not been made privy to the contents of the Krika report. The allegation by Ngoyi, Dingiswayo and Mokhashwa was never challenged by counsel when they testified. From the emails and reports quoted previously and in my summing up, it is clear from the contemporaneous expressions of these witnesses they were deprived of assessing for themselves whether the so-called concessions impacted upon the prospect of PRASA's defences in the litigation. In response to the allegation that she had settled the Sakaya claims, the respondent claimed that she had simply offered her expertise as a lawyer in assisting as the AG CEO to settle the matters to save PRASA from proceeding with needless and costly litigation. That was never put to any of the witness, that she was simply assisting Zide, who was then the AG CEO. This evidence came out during the course of her evidence before the tribunal. Under cross-examination, when she was asked whether it was fair to argue that witnesses were lying when they had not been given an opportunity to hear her version where her version was not put, the respondent testified thus: I did not argue in a vacuum that a witness is lying, and I have never used the word lie in this forum. Number one, I have never used that word. I can, and I have answered the question by saying someone is lying. That is in stark contrast and utterly inconsistent with the passages that I've previously quoted on page 126 of my heads. The respondent claimed that the relationship between the board and the legal team broke down after the suspension of the legal panel, after the so-called resolution of 1 December had suspended the legal panel. That was not so. That was inconsistent with the evidence of Botha's, the unchallenged evidence of Botha's, that she'd already, as early as her first contact, the tribunal will recall the contact took place on the 13th of November. That appears from the so-called cell phone record report, that was the first contact between them. She had indicated, Judge Makhubele had indicated, she did not trust the department. This evidence was not disputed when Botha gave his evidence. Under cross-examination, she belatedly claimed everything Botha says is actually the opposite. And this was also never put to Botha when he testified. From the numerous exchanges between Botha and her, which she relies on in support of the claim, there is no evidence of abuse. According to the uncontroverted evidence of Ngoyi and Dingiswayo, there were only 2 meetings between the legal department and the respondent. The legal department being the group legal services headed by Martha Ngoyi and the legal department managed by Fani Dingiswayo. And that was on the 9th of November 2017, at which Ngoyi and Dingiswayo attended, and on the 14th of November 2017, which Ngoyi attended. She testified that the legal department had welcomed the respondent's appointment as chairperson, believing that she would understand the challenges which PRASA faced. At the first meeting, the respondent made inquiries about the worksman's report. The tribunal will remember the worksman's report dealt with the Swifambo the Swifambo contract, at which Mr. Mackenzie Mabunda was quite involved, together with Mr. Lucky Montana, who was then the CEO. At the second meeting, she raised the Siyaya matters with Ngoyi after her meeting with Botha on the same day. In response to the claim that she had settled the Siyaya litigation herself and had not marginalized the legal department, she testified, I told you I was assisting, and this was the first time we heard that she was simply assisting the CEO, who, according to the delegation of authority, she said, had the power, the financial limit to settle the matters to save PRASA from proceeding with needless and costly litigation. It was not clear from her evidence who had mandated her. No resolution of the board was produced. Now, we respectfully submit that this evidence was inconsistent with the clear assertion of Mohashwa that the instruction to settle had come from the respondent. The respondent's version, again, was not put to Mohashwa for him to deal with. When pressed in cross-examination, she appeared again, and this became, pardon the expression, a mantra, to blame her counsel for the failure to challenge Mohashwa's evidence on the score. I go to page 130. Now, the tribunal president will remember quite clearly that he pressed Mr. Boertes to get clarity on who settled the matter. And Boertes referred to a WhatsApp message he received from the respondent at 13:44 on the 19th of December 2017, in which the respondent forwarded the instruction to make a settlement offer to Mohashwa. The effect of the instruction was that PRASA simply capitulated, or they just rolled over. Boertes testified he was pleasantly surprised he was not involved in any settlement negotiations. Now, this evidence was at odds with what Madam Justice Makhubele was telling us. The tribunal pertinently asked, who was it at PRASA who gave the instruction to settle? Well, unlike Mr. Mohashwa, who made it plain that it was the instruction from the chairperson of the board, Boertes simply dodged and weaved. He could not assist in any other way to say that the board must have given instruction to settle. Nor was Boertes able to assist in offering any reason why between September 2017 and 15 December 2017 the situation had changed so drastically. During cross-examination, she was asked about the letter which Malepa sent to Ngoyi, dated the 8th of March. The tribunal will remember that the 8th of March is an important date in the whole saga. It was the day that preceded the hearing of the matter before Holland Muter AJ in the Pretoria High Court, where the awards made by Judge Brunt were to be made orders of the court. It was conveyed that the respondent required to be advised whether her decision to settle the matter, the CIA matter, was being reviewed or challenged. The word her was used, not our decision, not the decision of the board, not the decision of the board and the AGCO, not the decision of Madam Justice Makhubele assisting the AGCO. It was her decision. And when the letter was raised with the respondent, she appeared to be unable to respond to the questions around this letter. She resorted, with respect, to being evasive again before addressing the contents of paragraph 2 of the letter. When it was put to her that the words attributed to her corresponded with Mohashwa's evidence that she had instructed the settlement, she claimed that the letter contained a wrong statement that it had only been concluded by her. 3 witnesses, Ngoyi, Dingiswayo, and Mohashwa, testified that the legal department had been excluded from participating in the process which led to the settlement offers being made. At no stage during cross-examination was this allegation challenged. The respondent belatedly claimed that there was nothing stopping the legal department from engaging with the board. However, Mohashwa confirmed that he'd been instructed not to involve the legal department because litigation was being managed by the board. And I have emphasized this in my heads on page 131. The legal department only got to know of the settlement in January 2018 when demands for payment were being made. If the tribunal remembers that by the 21st of December, the settlement offers were made, they were accepted on behalf of the CIA entities. And this was conveyed to the Madam Justice Makhubele. Then, soon thereafter, demands were being made for payment. That was in January, and these were not forthcoming. The respondent conceded that she'd been appointed as a non-executive director on the board of PRASA. She claimed that she had set about familiarizing herself with each unit. She accepted that she did not have the authority to deal with operational issues. She was shown the delegation of authorities that she had put up. That is now the Buthelezi delegation of authorities. The respondent again demonstrated that she was evasive in her respondence. It respectfully submitted that, judging from the way that the respondent dealt with this aspect of the evidence, it was clear that she had not understood what was required of her as the chairperson of IBOC. We respectfully submit that the performance of Madam Justice Makhubele on this score contrasted markedly with the evidence of Ngoyi. Ngoyi made it clear that in respect of the CIA matters, neither the board nor the AGCO had the authority to settle the claims which did not meet the thresholds as dictated by the delegation of authority. The authority vested with the legal department in conjunction with the chief executives of the PRASA units, and I ask you to see paragraphs 79 and 80 of the summing up. This evidence was not challenged by the respondent in cross-examination. However, the respondent sought to deny that this was so. We respectfully submit that to decide this issue, who settled the claims? Was it the respondent or was it somebody else? It is instructive to have regard to the various interactions and communications which the respondent had with Botha between 13 November 2017 and late May 2018. They are inconsistent with her claim that she was simply assisting Zide to settle the claims. On the evidence before the tribunal, she approached Botha in respect of the CIA matters in November 2014. She entertained a meeting with Botha on the 14th of November at PRASA, at which she received the Kricher report and his email of 6 September 2017. No sooner had Botha left, on the very same day she questioned Martha Ngoyi why the matters were being defended and not settled, which caused Ngoyi to be to be somewhat taken aback by this claim. We say, on the probabilities, that it could only have been based on the Kricher report that she came so swiftly to this conclusion. Botha had hardly left. She summoned Ngoyi to come and speak to her, and then put it to her, why are you people defending these claims? She nonetheless persisted in that view despite receiving the comprehensive reports from Mokhashwa, Dingiswayo, Kubue, and Baltak. If she had had any regard, as she claims to have done, to the comprehensive report, it is improbable that she would have persisted in her view. The tribunal will recall that she instructed that she required reports. Mokhashwa provided the first one on the 21st. She then sent an urgent memorandum, which was the internal memorandum of the 28th of November to Zide, and that in turn gave rise to a report by Fani Dingiswayo and a further report, two reports, which accompany that from Baltic and from Kubue. And furthermore, a report dated the 31st of November from Mokhashwa, in which he made it quite clear, and he attached several documents which should have persuaded the chairperson of the board, Madam Justice Makhubele, that these claims should not have been settled, but that they should have been, there were defenses that were available. It is also important to bear in mind that the reason we were told, or the urgent memorandum was required, was that Judge Makhubele intended to raise these matters at the board meeting on the 1st of December. That was the cause for the urgency of this memorandum. As matters transpired, it was never raised, or doesn't appear to have been raised, as appears from the minutes of the meeting of the 1st of December, that it was raised with the board. According to the evidence of Judge Makhubele, she engaged in her own investigation with witnesses who had made the so-called concessions, despite reports that she'd been furnished by Mokhashwa and the legal department. According to her own evidence, she invited the opposition leader, Botha, to PRASA to be part of the so-called negotiations on the 15th of December, at which she, according to Mokhashwa, dictated the terms to him. This was in the absence of the legal department, with whom Mokhashwa had been instructed not to speak to. Botha was unable to attend the meeting. Interestingly, PRASA had, in the course of defending these matters, been represented by a senior counsel, Mr. Tintswalo from the Johannesburg bar. Interestingly, he wasn't part of these negotiations, and you have to ask the question, why not? She forwarded, this is Judge Makhubele, the very instructions to Mokhashwa dated the 15th of September, drafted in the name of Zide, directly to Botha, and the probability is overwhelming that the original copy of the instructions on the PRASA letterhead, which Botha was able to produce to this tribunal, must have found its way to his chambers from her. The legal department were not favored with a copy of the very same instructions, and we have to ask ourselves, why not? Armed with the very instructions from the client, the respondent herself, to PRASA's lawyer, Matopo was able to undermine Mokhashwa by pointing out in his letter of the 19th of December that he had not, 18th of December, that he had not complied with his instructions. No sooner had Mokhashwa sent the amended settlement offers to include interest, which were accepted and had accordingly advised PRASA to this effect, the respondent sent an email to Mokhashwa on 21 December 2017, which included an instruction to Zide to finalize the matter with respect to the payment part. That document appears in Ngoya's Exhibits, Volume 9, 276. When payment was not forthcoming after the finance lady, that was a lady by the name of Page, Page had engaged with the legal department in January 2018. Botha communicated with the respondent. The respondent sent a message to Botha on 24 January 2018, in which she explained her quietness and expressed her shock and disgust at the open defiance displayed by the finance lady. Why? For any other reason than this was something which she had orchestrated. The payment, the settlement. On the 28th of January 2018, the respondent sent a message to Botha which read, "I want to talk to you urgently." On the 6th of February, the respondent forwarded Cromet Malekwa's contact numbers to Botha. Now she's the chairperson of the defendant institution. Botha is the hotshot lawyer of CIA entities. For what possible reason would she be engaging as a representative of the defendants, be engaging with Botha? And without the assistance of Mr. Tintswalo. On the 7th of February 2018, the date on which Judge Brunt made the arbitration awards, the respondent sent a message which was conveyed by Zide to Makhubele that Makhubele should confirm that the settlement be made an order and proceed with arbitration on the one that had been outstanding issues. On the following day, Malepo sent an email to set up a meeting. This obviously related to demands for payments being made. Her department and Ngoyi rightly said, we've got nothing to do with this. We weren't party to this. You cannot expect me to agree to support the way the matter was handled. On the 9th of February, Boertes again communicated directly with the respondent to advise her that Judge Brunt had made the awards. She thanked him for the update. On the 12th of February, the respondent sent a message to Boertes which read, "Can I call you later?" Boertes responded with a thumb up symbol. Later that same day, he communicated again and raised the issue of applications being made to enforce payment of the awards. She responded by saying that she would talk to Zide. On the 14th of February, Boertes messaged the respondent, "Dear Nana, do you have 2 minutes to talk to me?" The respondent answered, "Yes, you may call." These communications between Boertes and the respondents were taking place at a time when applications were being drafted by Boertes to make the awards, which were not being complied with by PRASA, orders of court. By 20 February, Makhubele had received the applications from Matopo, and these were forwarded by Mbebe, that was Mr. Makhubele's assistant, to Zide, who failed to give instructions whether to oppose the applications. The following direct intervention by the respondent, which culminated in the publication by Boertes of the message from her, Bowman's had no authority to act for PRASA. That appears in volume 20, 206 to 207, which he received from the respondents. This, in our respectful view, submission, blocked the attempts by the legal department to oppose the applications before Holland Muta AJ on 9 March and resulted in the orders being granted by default. Finally, there was a last-ditch attempt by the respondent to stamp her authority, as was made clear in the letter I've already referred to of the 8th of March 2018 of Malepo to Ngoyi. The sentiments in the letter clearly emanated from the respondent, and they weren't simply the language which Malepo would have used. The respondent was simply using Malepo to carry out her instruction that the opposition to the applications be withdrawn. On the 9th of March, Boertes sent the following message to the respondent. "Dear Nana, I trust you are well. Just to let you know that judgments was granted against PRASA in all 4 applications. The sheriff will serve the court orders on PRASA this afternoon. Enjoy your weekend. Kind regards, Francois Boertes." During May 2018, the respondent, this is now bearing in mind her evidence that she gave before this tribunal under oath, Judge Makhubele was still communicating with Boertes to enlist his assistant, describing him then, and I quote, "my so-called co-conspirator." Makhubele Exhibit, Volume 18, 98 to 103. These communications between them still had to do with Siyaya. This is consistent with her evidence that she communicated with Boertes up until, I beg your pardon, it's inconsistent that she communicated with Boertes up until March 2018. It depends on what we are talking about, but I had already informed him that he should not involve me, and if you care to read my response to him, I simply said thank you for the update. By way of marked contrast to her inclinations towards communicating so extensively with the representative of the opposition whose interests were at odds with those of PRASA, the respondent had only one direct engagement with the legal department, who was steeped in the litigation, and that was with Ngoyi on 14 November 2017. it is hardly surprising that in those circumstances they sought to describe the settlement of the litigation as secret. The evidence of the respondent was manifestly unsatisfactory under cross-examination, when her conduct in relation to these communications, which I've taken the trouble to read with Botha's, was probed. One of the few instructions, and coming back to the theme, one of the few instructions which the respondent gave to her counsel and which was put to Ngoyi, that the respondent would say that she gave no instructions regarding payment. However, the email that I've already referred to is inconsistent with this claim. The respondent had a rather tortuous explanation for the email which failed. We respectfully submit to satisfactorily explain why she had sent it. This was not the evidence of a mere assistance to Ezide. It revealed instead that it was the respondent herself who was giving instructions. We submit that the only reasonable inference which can be drawn from the conspectus of the evidence before the tribunal is that the respondent had usurped the functions of the executive of PRASA by instructing that settlement offers be made to the lawyers acting for PRASA. There was no evidence from Ngoyi or Dingiswayo that the respondent took an interest in settling other litigation apart from the CIA matters. The respondent, interesting herself, makes no mention of other litigation being settled. It is not clear why the claims had to be settled with such haste. The respondent mentioned in an email dated 7 December was sent inquiring whether a meeting with the legal department could be held and was told they were not available. It was festive season. Anybody who works at around about that time can expect, we'll be celebrating the season before we all go away on leave. But then the respondent, on her version, engaged in an inquiry with the PRASA employees who had made the concessions, which she set so much store by in pushing the settlement to be made. The respondent had never heard, and this is an important point, and I'm referring to paragraph 160. She had never heard of the existence of the chief executives of the units affected by her decision, namely Piet Sabola and Kevin Munsami. According to the delegation authority upon which she based her powers upon, they had to be consulted. That did not happen. This was the unchallenged evidence of Ngoyi and Dingiswayo. When she was pressed on it, it was quite clear that this was news to her. We respectfully submit then that the question which requires resolution by the tribunal arising from the second complaint is whether the conduct of the respondent can be described as gross misconduct as envisaged by 177. We point out, and I'm not going to go through the whole thing, I understand that the tribunal will have time to consider this. We refer to the Public Finance Management Act, which was binding upon and I've set out the various sections, including the fact that upon any reading of the evidence adduced before the tribunal, the conduct of the respondent brought her within the scope of the sanctions envisaged by Section 83 of the Act, that she committed acts of financial misconduct. Moreover, we respectfully submit there was strong prima facie evidence that her conduct amounted to criminal conduct in contravention of the provisions of Section 86 of the Act. Those provisions are quoted, and I don't want to burden the record at the moment with reading them out. We submit that through her unauthorized conduct, PRASA not only incurred fruitless and wasteful expenditure through the direct actions of the respondent, but the public entity also suffered a financial crisis in March 2018. The tribunal will recall the evidence that as a result of the orders of Holland Mutter on the 9th, applications were made for the sheriff to seize the funds to meet those orders in the amount of 56,029,560 rand and 95 cents. These were immediately removed from the bank accounts of PRASA. That they were not lost to the public purses, no thanks to the Madam Justice Makhubele. Had it not been for the action of the sheriff in holding the monies attached in his bank account, it would have been lost. The respondent owed a duty of care to PRASA to ensure that she acted as a good steward of PRASA's assets. In this regard, she failed. My learned friends, on behalf of, acting on behalf of Unite Behind, refer us to, have referred to the decision of Madam Justice Tolmay, sitting in the Gauteng High Court, of the matter of Outer, A-O-U-T, versus Myeni. Madam Justice Tolmay said, in regard to the provisions of the PFMA, and particularly in regard to Section 50 and Section 51, that a heightened sense of care, fiduciary duty, is required. We submit that there can be no doubt the respondent's decision to settle the CIA claims against PRASA in the face of the resolute defense of the claim over a period of several years. The respondent, Madam Justice Makhubele, failed to act in the best interest of PRASA. This what she was required to do by the Act as the accounting authority. She had no authority to settle the claims, even in concert with Zide, as she claimed. The four claims individually fell below the amounts which would have justified intervention by the GCEO, let alone the board. And we say that in arriving at a settlement, she failed to comply, to involve the Strategic Asset Development or PRASA Tech. They were never approached, and whether they should be, the claim should be settled despite being the relevant department. In this regard, we make the point that transparency is a pillar of good governance. In this regard, the respondent failed to act transparently towards the above-mentioned entities, namely the executive authorities who allegedly had incurred these claims for services allegedly rendered by them. In this regard, we say that the respondent failed to act transparently. We furthermore make the submission that, and I'm referring to 176, paragraph 176, that PRASA suffered fruitless expenditure in respect of the ENS opinion, which the respondent conveniently ignored because it did not suit her narrative. She had interacted with her fellow board members, which no doubt led to the further fruitless expenditure to get another opinion. I deal then with the evidence relating to the ENS opinion. We also point out that the respondent was pertinently made aware that the meeting of the 1st of December was inchoate. This is borne out by the minute of the meeting where Zide drew attention to the fact that the board was inchoate. Resolutions that were allegedly passed by the board prompted Ngoye and Dingizwaya to write a memorandum to the respondent of the 5th of December 2017. They received no response from Madam Justice Makhubele as the chairperson of the board. I turn to page 148. The tribunal will recall that on the 16th of March 2018, Madam Justice Makhubele resigned. That was a Friday. And we respectfully submit that her conduct on the 19th of March 2018 is curious, to say the least. According to a letter from Zide, dated the 22nd of March, addressed to Mr. Mbata of ENS Africa, this was the rejection of their opinion. But he notes, I have been instructed by the chairperson of the board on Monday, 19 March, to formally advise you the board has unanimously rejected to accept the opinion given. Considering that Madam Justice Makhubele had severed her ties with the board by resigning on Friday, the 16th of March 2018, her actions appeared to be unlawful. Given the controversy which was by then brewing around her conduct in relation to the PRASA matter, the timing of the decision to seek a second opinion appears to be a vain attempt at damage control by the respondent, and it is difficult to understand why it was necessary to seek an opinion as to her status as a judge, when according to her evidence, she was not a judge on the 1st of January. We also submit that it's deeply disturbing that despite being advised that the board was inchoate as the 1st of December 2017, when the so-called resolutions were passed, the respondent saw fit to send a message to Botha shortly before the hearing of the applications on 9 March, claiming that the legal panel had been suspended and that Bowmans had no authority to act for PRASA. We submit that this is manifestly untrue. The respondent must have foreseen that armed with such inside information from the chairperson of the board, Botha would have used it to his advantage by publishing it to the court if a need arose. He did so successfully, in that it appears that this influenced Holland Muter to find that Bowmans had no authority to appear on behalf of PRASA, and led Mr. Justice Holland Muter to grant orders against PRASA by default. This act of sending such messages to Botha, considering the contents thereof, cannot be construed as acting in the best interests of PRASA. All communications between PRASA and CIA should have been between counsel representing the entity and CIA's representative. We point out that further fruitless expenditure would have been incurred by PRASA to pursue the rescission of the orders of Holland Muter at great cost to PRASA on account of the respondent's unlawful actions. In this regard, the respondent also failed to protect PRASA from incurring unjustified liability. The subsequent rescission of the orders and the failure by the CIA entities to this day to pursue claims which respondents thought could not be defended underscore the irrationality of Madam Justice Makhubele's conduct while she was chairperson at PRASA. We submit to the further infringement of her fiduciary duty was required of her was that she act with fidelity, honesty, integrity, and in the best interests of the public entity in managing the financial affairs of the public entity. Her conduct in marginalizing the legal department illustrates her failure to observe the standard of conduct which the law demanded of her. Considered objectively, her conduct as a public official could not be considered as adequate or satisfactory for an official in her position. On the contrary, her conduct was arbitrary and was not consistent with the rule of law. Her conduct fell short of the standards demanded by the Constitution. Judge Makhubele's decision to push through the settlement of the CIA claims made no rational business sense in the context of the interests of PRASA, based on all the facts which were available to her. She accordingly failed to discharge her duties of good faith and care as the non-executive director of PRASA. At 186, we point out that the so-called major concessions were not points of dispute. The concessions made did not relate to the points that PRASA had made in defending the claims. And in spite of this, the respondent drove the settlement. We invite the tribunal to have regard to the so-called Krieger report, to look at whether there is any major concession that arises from a reading of that report. And we respectfully submit that there were none that could be said to have undermined PRASA's defences as claimed by Madam Justice Makhubele. Article 5 of the Code of Judicial Conduct stipulates that a judge must always, and not only in the discharge of official duties, act honourably and in a manner befitting judicial office. We respectfully submit that, unfortunately, the conduct of Madam Justice Makhubele on the evidence before this tribunal cannot be said to have measured to the standard required of the holder of a judicial office. Whether Madam Justice Makhubele was in active service or not active service, it matters not. She was not only on the brink of taking up a judicial appointment in November 27, but she was also a judge as of 1 January 2018 when she committed the misdemeanors complained of by Unite Behind in relation to the second complaint. Article 6 of the Code of Judicial Conduct requires that a judge must at all times, also in relation to extrajudicial conduct, comply with the law of the land. As I hope we have been able to demonstrate in the submissions we've made, the respondent was not compliant with the law of the land. I wish to quote from the report of the Judicial Conduct Tribunal in re Judge N.J. Motata, where the following was said, which we respectfully submit is opposite to the instant matter. The office of a judge is a very respectful office. So must be those who hold it. The judge's conduct in and out of court should not dishonor that high office. Impeccable moral and ethical standing is a crucial hallmark of such a public office. The respondent's conduct in relation to PRASA, as well as the way she conducted herself before the tribunal in the full glare of the publicity afforded to this matter, we respectfully submit, has threatened public confidence in the judicial system. And we respectfully submit that on the aforementioned grounds relating to the second complaint, the tribunal ought to conclude that the respondent is guilty of gross misconduct as envisaged by Section 177 of the Constitution. Those are the submissions I wish to make. May I just confer with my leader?
Yes, we will take the lunch adjournment, and during the adjournment you may confer, and you may then round up after the adjournment.
I'll appreciate that.
With the complainant version on count 2 to deal with it. Thank you. We then stand adjourned until, yeah, 2:15, Judge Mashidi. Yes. We will, yeah. Yeah. 2:15. Yeah.
And what transpired from the email, which was then directed to the members of the board, including one Kolisile George, or Kolile George, who was a member of the board. And during the course of that email, the question of the Siyangena was raised, but also the question of Siyaya. The significance of this email the significance of the email consists in the fact that Kolile George instructed the officials at PRASA to fight the Siyaya claims. In other words, he meant that they should proceed to try to recover that money. Now, the significance of this is that here is a member of the board who obviously had no knowledge of what had transpired with regard to the Siyaya settlements. Whereas in fact, it was conveyed to Mahashwa that the matter was being dealt with by the board. Again, this piece of evidence is inconsistent with Judge Makhubele's claim that the board was in charge of the settlement of the claim. And finally, I just want to refer to paragraph 58 of the heads of argument submitted on behalf of Judge Makhubele, the first lot. It reads thus: prior to her appointment as a judge of the High Court, Justice Makhubele, 58, Judge Mashidi, 58, page 19 of the heads of argument introduced, the first set introduced on respondents' submission, written submissions. Prior to appointment as a judge of the High Court, Justice Makhubele was approached by the Minister of Transport to avail herself for a short-term appointment as chairperson of the Interim Board of Control of PRASA. She accepted the invitation and submitted to the Minister her CV. There was no interview conducted for this position, which she was subsequently appointed to on the basis that this would be a short-term appointment. Why I raise this? Because my understanding of the evidence of Judge Makhubele was to the effect that she had no knowledge that the appointment was in respect of the Interim Board of Control of PRASA. We were told by Judge Makhubele that she was approached by a Mr. Richard Chauke, or Dr. Richard Chauke, it appears, a neighbor, who told her that the minister was under some pressure to institute boards of control for the Department of Transport, and that she then surrendered her CV to him, and she heard nothing further. This was in about September, she told us. Now, we question how this statement in paragraph 58 corresponds to what Judge Makhubele testified to in this tribunal. It appears to be at odds with the evidence that was adduced. have no further submissions to make.
Thank you. We will hear then from Mr. Bishop. You on, Mr. Bishop?
Thank you.
This is for the complainant. This may be of some assistance to you. You have submitted heads of argument. So we have the heads of argument. You're, of course, free to point out anything that you would like us to take note of, but we have the heads, and bear that in mind as you go along. Thank you.
Thank you very much, President Japp. Yeah, I don't intend to repeat the heads. The approach I want to take is just to briefly summarize the case for the complainants, and I'm, again, going to try not to repeat much of what
Yes.
Mr. Paver said, and then to really focus my submissions on the defenses that have been raised by Judge Makhubele in her heads of argument and what our response is to those defenses. Just two quick items of housekeeping, President. We've prepared a bundle just with all the authorities that are mentioned in the heads of argument. I'm not going to provide it to you now because I don't intend to take the tribunal to it, but we'll make sure that it's made available to the tribunal, just so you have all those authorities if the tribunal wishes to look at them.
Yes.
There are two authorities that I do intend to take the tribunal to, which I would like to provide copies of. If I may hand those up.
Yes.
There is also a copy for my learned friend. We'll arrange for an electronic copy to be sent. Thank you, President. Before I begin with Part A, so the first case is the Van Rooyen case, which is a judgment of the Constitutional Court, and the second is Kanyile, which is a judgment of the Labour Court. Thank you, President Japp. I just wanted to begin with what the standard is. We deal with it in the heads, but I just want to refer to what we mentioned in paragraph 18 of the heads, which was adopted by the Supreme Court of Appeal recently in dealing with the appeal concerning Judge Matata. And they quote from a Canadian case and appear to endorse the following proposition, which is that before making a recommendation that a judge be removed, the question to be asked is whether the conduct for which he or she is blamed is so manifestly and totally contrary to the impartiality, integrity, and independence of the judiciary that the confidence of individuals appearing before the judge, of the public in its justice system, would be undermined, rendering the judge incapable of performing the duties of his or her office. So that really is the same standard that Mr. Paver referred to, that does the misconduct rise to a level that allowing this person to remain on the bench would undermine public confidence in the judiciary. And if it does, then it is gross misconduct. To turn to Part A, President Jappi, I'm going to start just with a very brief summary of the facts, because I think the facts are largely common cause. And I'm going to deal briefly with why the version of Judge President Mlambo should be preferred, with why Judge Makhubele was a judge on the 1st of January 2018, and why that renders her guilty of gross misconduct. So very simply, what occurred is that prior to her interview, Judge Makhubele had some conversations with JP Mlambo about starting dates, but there was no agreement. Nothing was mentioned at the JSC that she might have to start at a different date. After the JSC interview, she accepts the position at PRASA and doesn't tell the Judge President that she has done so. There's communication between her and the Judge President in October, where he says, "You will be appointed from the 1st of January. She replies saying, "I may want to consider my position." He says, "Let me know." And she doesn't write back. Until the 4th of December, That's the first time, the very first time she says to the judge president, I would like to start on the 1st of April. The judge president has been no writes back and says, I'm sorry, your delay has been your undoing. The president has already signed a letter of appointment for 1 January. There is then a dispute about whether there was a meeting that occurred on the 14th of December 2017 between the JP and Judge Makhubele. Judge Makhubele says there was a meeting, and at the meeting, JP Mlambo said this certificate of appointment is invalid, and I agree, you only have to start on the 1st of April. Judge Mlambo's version, it was put to him in cross-examination that there was a meeting. He said there may have been a meeting. I can't recall. I'm not sure whether there was a meeting or not. It was then put to him by Mr. Maleka that at the meeting there was an agreement to remove her from the duty roster, and he strenuously denied that. He said there was no such agreement. It wasn't put to him in cross-examination that there was an agreement between him and Judge Makhubele at this December meeting that she would start on the 1st of April 2018. We then get to the 1st of January. Judge Makhubele becomes a judge. She doesn't come to take the oath. JP Mlambo phones her and says, all the other judges who were appointed have come in. You haven't come in. Please come in and take the oath so you can start your work. You're on the rolls. She says, no, there's a problem. I can't take the oath. I can't start my work. He says, come in and talk about it. They have a meeting, 2nd week of December. We're not sure the exact date. DJP Ledwaba is there as well. And this is the key meeting, which Judge Makhubele denied occurred at all, but both Judge President Mlambo and DJP Ledwaba confirm occurred and confirm exactly the same details of what happened at the meeting.
When you say you talk about the second meeting now, are you talking the one in mid-January
Yes.
2018?
Yes, the one in mid-January. There's a dispute about whether there was a meeting in mid-December 2017 and what happened.
Yes.
And then there's a dispute about the mid-January 2018 meeting.
Yeah.
And so what happened at the meeting? The DJP and the JP ask her, why haven't you come in to take the oath? She initially says, Water Tribunal, I have other cases in the Constitutional Court. JP Mlambo says, that's no excuse, come and take the oath. That doesn't stop you being a judge. She pushes it, she doesn't accept it. And JP Mlambo then says to her, is it because of PRASA? I read in the press that you're the chairperson of PRASA, is that why? And she then says, yes, I am the chairperson of PRASA, and I don't want to come and take the oath. I don't want to do my job for that reason. And the DJP says to her, please, you should resign. He tries to convince her to resign a position from PRASA to come to perform her work as a judge. And she refuses, and she says she doesn't want to because she doesn't want to disappoint the minister. The JP then, as Mr. Pava put it, is stuck with a mess. They have a judge who's appointed but who won't come and take the oath. So he writes to the minister to ask for what he calls a deferral of the appointment and 2 acting judges. There's a question put by Judge Mashidi to Mr. Pava about what do we make of that Judge J.P. Mlambo didn't immediately write to the JSC. And with respect to J.P. Mlambo, I think it would have been appropriate for him to approach the JSC at that point. Because on the complainant's approach, at that point, her gross misconduct was final. Her gross misconduct, she refused to take the oath, despite being asked to and requested repeatedly by the leaders of her division. She was guilty of gross misconduct, and they should have reported her to the JSC. But this tribunal is not interested in whether J.P. Mlambo acted or not. And what J.P. Mlambo did not do can't help Judge Makhubele. That process is in motion, the so-called deferral. Judge Makhubele resigns from PRASA on the 16th of March. And then towards the end, I believe it's in end of March or beginning of April, she approaches Judge Mlambo and says, please, I want to come and take the oath. I've resigned all my positions, I'm unemployed, I need to take the oath so I can start my work. And J.P. Mlambo says, no, not until I hear back from the minister and the president about my request for your deferral. That's eventually, the decision is taken on the 22nd of May, and the president issues a new appointment that is effective with effect from 1 June 2018. And the key factual debate here is really about the meeting in January 2018. Because if the meeting in January 2018 occurred as JP Mlambo and DJP Ledwaba say it did, that also renders her, Judge Makhubele's claim about the meeting in December 2017, it's completely irreconcilable. Because if there had been a meeting in December 2017 where JP Mlambo said, yes, you can start in the 1st of April, the meeting in January makes no sense whatsoever. So either both are, Judge Makhubele's version must be accepted on both, or JP Mlambo's version must be accepted on both, because you can't have one sitting with the other. And we've set out in detail in our heads why the JP Mlambo's version should be accepted, and I don't intend to belabor the point. There's really 5 reasons. It was never put to him in cross-examination, and we know what the inference is that should be drawn from that. There's corroboration of JP Mlambo's version in the affidavit of DJP Ledwaba. And we know why DJP Ledwaba wasn't called. He was sitting in the reception area. He was ready to testify. The only reason was because this issue was not challenged in cross-examination. So it's not that the fact that he didn't testify shouldn't be used to discredit the version. The third reason is that it's consistent with the timeline. And particularly when JP Mlambo writes to the minister, he writes on the 22nd of January. If he knew on the 14th of December that one of his judges wasn't going to come to work until April, it is extremely unlikely that he would have waited until the 22nd of January to ask for a replacement. The fourth reason is that there is no incentive for JP Mlambo and DJP Ledwaba to lie. There is an incentive for Judge Makhubele to lie. Because, as I'll get to in more detail, if this meeting occurred as Mlambo JP said it did, she is undoubtedly guilty of gross misconduct. And the fifth reason is the performance of the witnesses. Judge Makhubele was an unsatisfactory witness. She was evasive and obstructive. Judge Mlambo was an entirely satisfactory witness. So for all those reasons, we say this tribunal has no choice but to accept the version of Judge President Mlambo. So that then brings us to the question of what's really a legal question, which is, was Judge Makhubele a judge on the 1st of January 2018? Because the point's been taken that she wasn't a judge because of the later decision of the president. This point doesn't seem to be persisted in the heads, but it was advanced by Advocate Maleka in cross-examination. And our position on this is very simple. A judge is a judge from the moment they're appointed by the president. Only a judge who has been appointed can take the oath. You don't become a judge when you take the oath. You must be a judge before you can take the oath. And that's clear. We set out in the heads. If you look at the constitutional provisions, you look at the schedule which contains the oath, only a judge may take it. So she was already a judge before she...
Let's just stop at that point.
Yes.
I've had a look at the heads, and I would just like you to explain that concept. When does a person become a judge? Does a person become a judge on the appointment by the president, or does the person become a judge only when they take the oath? What's the difference and why?
Yes. So you become a judge on appointment because that's what the Constitution says. It says the president appoints somebody as a judicial officer. And then it says a judge must take the oath before you can perform your judicial duties. And so you must be a judge before you even can take the oath. If you try to take the oath before you've received an appointment, that's not a valid oath. It has no effect. It has no consequence. So you must be a judge first, and then you're qualified to take the oath. You may not hear a case before you've taken the oath.
So if something that we often struggle with, one is substantive and the other one is procedural. Would that be correct?
Yes.
It's substantive to be appointed and it's procedural to take the oath.
Yes.
Is that the point, as I understand the argument?
Yes, President.
Yeah, okay.
Yes. And so the first certificate of appointment from President Zuma says Judge Makhubele is a judge from the 1st of January 2018. So from that date she was, and when the meeting occurs in mid-January, she was a judge. Whatever may have happened down the line in the future, at that moment in time she was a judge. And what this tribunal must assess is whether her conduct at that moment in time was ethical or unethical. And so whether the president had the power to change the date of appointment, to issue a new certificate of appointment, we say that's unlikely. The state law advisor suggested that he didn't have that power, but this tribunal need not decide that, because the president might have been able to change the legal consequences, but he couldn't change whether Judge Makhubele acted ethically at the time. If she acted unethically by refusing to take the oath, refusing to take up her position in preference for serving on an organ of state regulated by the executive, if that was unethical when she did it, it cannot be rendered ethical by what happened down the line a few months later when the president took a decision. Because when she acted, Judge Makhubele acted, she had no idea what President Ramaphosa would do in the future. He may have changed the appointment, he may have said, no, I'm not going to do it. And so what this tribunal is concerned with is the ethics of her conduct at the time, not the technical legalities about what the consequences of, whether the president was functus officio or not, whether he could change the date or not, whether that acted retrospectively or not. None of that matters to the ethics of her conduct.
But then another question arises. Is it, I hear you saying it's irrelevant. Is it competent for the president to appoint one person twice for the same period?
We would say
Is
no.
it competent?
We would say no, Judge Mashidi, but it's not for this tribunal to review the president's conduct.
I know I said that.
Yes. So it's certainly open to abuse if you say the president can appoint a judge and then can, at a time after the date of appointment has started, because remember that the date of appointment has started, can at any point thereafter change that date. That would be open to serious manipulation. I'm not saying that's what President Ramaphosa did here. I don't think this was a case of manipulation by the president, but it's open to that abuse. And so we would say that the president should not have that power. But this tribunal doesn't need to decide that. It should not decide it. It's not a court reviewing the president's conduct. Whether he had the power or not, and whatever the retrospective consequence of his decision may have been, Judge Makhubele acted unethically when she went to that meeting and said, I refuse to take the oath, and nothing could wash that sin clean.
So it is the complainant's argument on, let's call it the first transgression, would have occurred around the 15th of January or the mid of January as testified to. The first problem we have, did it happen or didn't happen?
Yes.
If we assume it didn't happen, then there is no misconduct because the misconduct happened on that day.
Yes, I accept that.
If we assume it did happen, then you say that is the date we've got to look at, and that's the date on
Yes.
which Judge Makhubele's conduct must be judged as to whether it is gross misconduct by her refusal to taking up the position.
Exactly.
Is that the argument?
That's the argument.
Yes, thank you.
Yes, because if her version is that before the date of appointment, she had an agreement with the Judge President about the 1st of April 2018. If that was the case, then there would still be this problem of the overlap, but it would be difficult to say it was gross misconduct because she would have had the prior approval of the Judge President, and it would have been a technical question of trying to sort out the appointment date. But that's not what happened. What happened is that she was a judge and refused to take the oath.
And, is it possible that during that process of trying to make Judge Makhubele commence her duties on the 1st of January, that there could have been a mistake or miscommunication between Judge J.P. Mlambo and Judge Makhubele, just on that aspect? Is it possible? Is there room to think that there could have been misunderstanding, miscommunication?
I don't think it's possible if one looks at the testimony of Judge President Mlambo and DJP Ladwaba, because they're very clear about what happened at the meeting, that they expected her to take the oath. That's why the meeting occurred, because JPM Lumber called her beforehand and said, why haven't you come in to take the oath? And then he said, come in and let's talk about it. And then they they both say, DJP Ladwabe in particular tried to convince her to resign from PRASA to take the oath, and she refused. So I don't think there can be any miscommunication. And I'll get to later to show that she also knew she was a judge. She acted on the basis that she was a judge from the 1st of January. That was her own view at the time. She now renounces that view with this argument about the employment contract that I'll get to. But at the time, that was her view. She believed she was a judge. And she was entitled to take the oath.
I mention this because the discussion as to when would she start commenced even before the interview with the JC.
Yes.
It's a long time, and
Yes.
one asked the question that over that extended period of discussing one aspect of the matter, could there have been the minds not meeting at all?
Well, I think if you look at the correspondence, Judge Mashidi, the October correspondence, where it's clear that Judge President Mlambo says 1st of January, there's no doubt about that. Judge Makhubele says, I'm not sure, I want to have discussions. JPM Mlambo writes back and says, I'm free to meet. And then she waits until the 4th of December to write and say, I would like to start on the 1st of April. He immediately says, I'm sorry, you waited too long, your delay has been your undoing. So I think that clearly there was some discussion, but by the time you get to the 1st of January, the position was clear. JPM Mlambo said, no, it's too late, the certificate of appointment has been signed, you are a judge from the 1st of January, and that's why he asks her to take the oath. That's why she's on the roll, why he's surprised she hasn't come in yet to take the oath when all the other judges had. So there could not have been a miscommunication. And any miscommunication that may have been would have been dispelled at the meeting.
Could, during the time when JP Mlambo took or indicated to Judge Makhubele to say, I've got your certificate, but I'm going to withhold it, could that not have been a misunderstanding of the starting time?
Well, that was, sorry, Commissioner Madubeselevu, that was Judge Makhubele's evidence, but that wasn't Judge Mlambo's evidence that he was going to withhold the certificate. So, and that was never put to him, that he'd said this occurred at the meeting on the 14th of December 2017. It was never put to him that he'd said that at that meeting. And doing that would have been entirely inconsistent with his prior conduct and his subsequent conduct. So I don't think that this tribunal can accept that that occurred at the meeting on the 14th of December. It's inconsistent with the facts before this tribunal, and it was never put to him to answer. So that's why we submit that there was gross misconduct. I mean, we submit briefly that there's 7 layers to that misconduct. So the first is that Judge Makhubele was receiving external income other than as a judge, and that violates Section 11 of the JSC Act and Article 15. The second layer is that she performed work other than as a judge, and that's contrary to Article 12. The third layer is that she wasn't just doing any work, she was working for an organ of state that was mired in allegations of corruption, creating political controversy, and that's contrary to Articles 12 and 14. The fourth, and really I think the most serious part, is that she refused to do her job. The most basic obligation of a judge must be to come to court, to hear cases, to write judgments. And somebody who refuses to do that is guilty of gross misconduct. And that's contrary to Article 14. The fifth is that she didn't act consistently with the independence of the judiciary. And Article 4 of the Code of Conduct says a judge must uphold the independence and integrity of the judiciary and the authority of the courts, maintain an independence of mind in the performance of judicial duties, take all reasonable steps to ensure that no person or organ of state interferes with the functioning of the courts. What Judge Makhubele did is, while she was a judge, work as the chairperson for an organ of state. That is fundamentally inconsistent with the separation of powers and therefore the independence of the judiciary. The sixth and seventh layers arise from how Judge Makhubele conducted herself at the tribunal, because what she did is she accused Judge President Mlambo and Deputy Judge President Ledwaba of lying. She carefully chose not to use those words, but her testimony is clear. They were not telling the truth about whether that meeting in the middle of January occurred or not. That was her testimony. It was made publicly. This tribunal is broadcast on YouTube. And so she accused them of lying under oath, both of them. And in the Hlophe JCT, this was a consideration that tribunal took into account. That Judge President Hlophe in the tribunal and in the many years before the tribunal had made allegations against the other Constitutional Court judges, particularly against Chief Justice Lange, Deputy Chief Justice Mark Seneke, and Justice Japton in Kabinde, had accused them of lying. And that was taken as an exacerbating factor in considering the misconduct. And if she's falsely accused Judge President Mlambo and DJP Ledwaba of lying, that also means she has not been honest under oath. And that was a factor taken into account in the Motata JCT, in finding that he was guilty of gross misconduct. Because what ultimately the Supreme Court of Appeal found, and the tribunal found, was that he had acted dishonestly not only in his criminal trial, but also before the tribunal. And then that was a reason to find gross misconduct. And so we submit that this tribunal should make that finding with respect to Judge Makhubele as well. And I want to turn to the defenses. And the way we see that there's effectively two defenses. The first one is a legal defense, which is this argument about the employment contract, and that Judge Makhubele was not a judge because there had been no finalized employment contract. She hadn't accepted the offer. And the second is an attempt to say that the differences between her testimony and Judge President Mlambo's testimony are inconsequential, or that they can be read together, that they're not inconsistent. So both those arguments are made in the heads and the supplementary submissions. So I'm going to start with the argument about employees, and it faces two problems. So sorry, President Japia, unfortunately it's not in the heads because it's...
Yes, sorry, I wasn't. You say it is not in the heads.
Because unfortunately it's an argument raised for the first time in Judge Makhubele's head, so we didn't have an opportunity to deal with it in our heads. So this is the first opportunity we have. So the two problems with it are firstly that it's wrong in law, and the second one is that it's inconsistent with the facts. So the argument is based on two assumptions. The first assumption is that judges are employees, and the second assumption is that judges are appointed by contract. And both those assumptions are wrong. We know the first one, that judges are employees, is wrong because the Constitutional Court said so. I handed up at that fat bundle, the Van Rooyen decision, which, as I'm sure the members of the tribunal are aware, is a decision dealing with the magistrates and various provisions of the Magistrates Court Act and regulations. But the important part I want to take the tribunal to is paragraph 139. So the context in which Chief Justice Chaskelson gets in 139 is an argument about how the salaries for judicial officers, for magistrates, are set. And he makes a point that it wouldn't be appropriate for judges or magistrates to engage in the normal form of collective bargaining to increase their salary by going on strike. And then what he says in paragraph 139 is he says judicial officers ought not to be put in a position of having to engage in negotiations with the executive over their salaries. They are judicial officers, not employees, and cannot and should not resort to industrial action to advance their interests in the condition of service. So the Constitutional Court is very clear that they are not employees. They are judicial officers appointed, they hold constitutional office. They're appointed by the President on the advice of the JSC. And they're not employees of the state. And this was directly applied, this dictum, in the other case I handed up, the much thinner one, which is the Kanyile case, So this was a case in which a magistrate had approached the Commission for Conciliation, Mediation and Arbitration, and then there was a review of that decision to the Labour Court. And the question for Murphy AJ was whether the magistrate was an employee under the Labour Relations Act or not. Because if he wasn't an employee, then the CCMA had no jurisdiction, and the Labour Court had no jurisdiction. And if I can take the court to paragraph 27. So Murphy AJ discusses Van Rooyen, quotes the passage I took you to now, and then says, Van Rooyen strongly suggests that by virtue of their office, magistrates should not be seen as employees entitled to engage in the process of the Labour Relations Act for the purposes of protecting their rights. As judicial officers, they hold constitutional and statutory office, and the requirements of judicial independence render it inappropriate for commissioners of the CCMA who are not judicial officers to pronounce on their conduct or suitability for promotion. And he says later he makes a clear finding that they are not judicial officer, they are a judicial officer and not an employee. And in reaching that finding, he relies on two foreign cases, one from the Namibian Supreme Court, the Namibian High Court, and one from the Indian Supreme Court. The first appears at paragraph 31, and it's a judgment of Ngwepe AJ, who was acting, sorry, it's at the Labour Court, not the High Court. He quotes it in paragraph 31 of his judgment, and this is what Ngwepe AJ said. It is not only a question of the absence of supervision and control, but also prohibition of any interference with the judge in the execution of his or her judicial functions. It would be difficult to reconcile an employee-employer relationship with judicial independence. The confidence of citizens in the judiciary would be seriously undermined, particularly in matters in which the state is one of the litigants, a daily occurrence. So the argument that Judge Makhubele puts forward is that she's employed by the president, and there must be a contract of employment between her and the president, which they agree to. But what this shows is if that's the case, that's fundamentally inconsistent with judicial independence. And that's also what the Supreme Court of India found in the Union of India versus Pratibha Banerjee case. I'm not going to read it, but it's quoted as well in the Kanyile judgment, and they make exactly the same point, that this idea of what they call a master-servant relationship between a judge and the state is fundamentally inconsistent with judicial independence, and that therefore judges cannot be regarded as employees. They are constitutional office bearers. And that means that they're not appointed by contract. The act of appointing a judge is a public law act. The process by which a judge is appointed is set out in the Constitution, read with the JSC Act. You apply for, or you are nominated for the position, you accept the nomination, or you make the application to the JSC. The JSC interviews you, and they advise the president to appoint you, and the president appoints you. That is a public law process. It's not a contractual process. And so there's no contract of employment between a judge and the state. You don't sign a contract of employment. Your conditions are determined by Judge Jatti and Judge Mashidi. Your conditions of employment are determined by the Judge's Remuneration and Conditions of Employment Act. They're determined by statute, not by contract. So one just has to think about what the consequences would be if judges were treated as employees. Firstly, we wouldn't be here. There would have been a CCMA complaint against Judge Makhubele, and it would have gone through the labor courts. But precisely because judges are different, there's a whole different process for dealing with misconduct by judges, which is a public law process, not a contractual or a labor law process. So the whole argument about an employment contract falls flat. It's irrelevant. There was no requirement in order for Judge Makhubele to be a judge for her to accept the offer of the president. She made herself available for appointment by being interviewed by the JSC, and she was then appointed. And that made her a judge with nothing more.
What do you say? What was her date of appointment? Was it, as Judge Mlambo first testified, 1st January? Could that have been extended? What would be the position? At public law, not by contract.
It was 1st January 2018 was the date of appointment. That's it. in my submission, President Japie, it wasn't competent for the President to change that subsequently. It may have been competent to change it before the date. So if the President before the 1st of January had changed the date, that might be competent, because you can think of situations quite innocently where that would be required. But after the date, it wasn't competent for the President to change it. But even if it was competent, I've made the submission that it doesn't matter. Yes. So that's why this argument about the employment contract is wrong as a matter of law, but it's also inconsistent with the facts. It's a novel argument that we heard for the first time when we read the heads of argument. It didn't, the way we listened to the evidence and the cross-examination, come up before in this tribunal. And of course, Judge Makhubele is entitled to raise new legal arguments. We're not saying she's not permitted to do it. But we submit there's a reason that it didn't come up in the evidence, because it's inconsistent with the evidence. And we say that for a number of reasons. Firstly, one won't find this language anywhere in the communication between JP Mlambo and Judge Makhubele. Nowhere does Judge Makhubele say, "Thank you for your offer of employment. I wish to make a counteroffer that I begin on 1 April 2018. That's not the language that they're speaking, because that's not how they understand it. But I think, let me skip to what I think is the most telling part, which is the letter that Judge Makhubele writes to the Minister on the 13th of May, 2018. And it appears in Core Bundle, Volume 17, page 343. And so it's Core Bundle 17, page 343. So this is a letter that Judge Makhubele writes to the Minister. I think Mr. Paver took the court to it previously, where she's effectively saying, please, I want to come and act. Why is there this delay with the deferral of my appointment? Well, you've got the legal opinion. Why is the President not decided? But if one looks at paragraph 2 of that letter, and then I'll take you to paragraph 10 as well, she says, before this letter was addressed to you, I had met with the JP and his Pretoria High Court Deputy, DJP Ledwaba, on 13 March 2018, and we had agreed that I was going to commence duties during the second week of recess, that is 9 April 2018. This did not happen. How could she commence duties if this was an employment situation and there needed to be a contract where she still had to get the acceptance of the President to a proposed new date? Because that's the theory. The President came and said, I propose you start on 1st of January. She made a counteroffer 1st of April, and she's waiting for the President to either accept or not accept the 1st of April counteroffer. That's the theory that's made in the heads. But if that's the case, how could she start before she'd heard the counteroffer? But she's willing to start. And then she says in paragraph 10, and this I think is really the end of the argument, I kindly request you to advise me as a matter of urgency whether there are still any other issues that hinder the signing of my certificate of appointment, whether the issues are capable of resolution and expected duration thereof. This is to enable me to exercise my options, which include assumption of duties on the basis of the existing certificate of appointment, if the President is not able to accede to the request to change the date of my appointment as a judge. So she says, I accept that this original one is valid, and I will go and work on that basis, even if you don't sign a new one.
What certificate are we talking about?
The first certificate, so the one that President Zuma signed in
January.
In November for a start date on January. Yes. So what she's saying is this is before President Ramaphosa signs a second certificate. I'm willing to come to work on the first one. So she's accepting that that's a valid certificate of appointment. That was her position at the time. And that's fundamentally inconsistent with the argument that's now advanced. She says later, paragraph 10.3, I'm tendering to commence my duties as a judge within 3 days of this letter. It's also, Judge Makhubele, in her capacity as chairperson of PRASA, had commissioned the opinion from ENS attorneys. And that opinion advised her that she was a judge. I think she receives it in February 2018. She received this opinion from ENS advising her that she's a judge. Her testimony was that the PRASA board resolved to reject the opinion, not because they disagreed with the substantive content of it, but because they took the view that it went beyond the brief. But she's advised then as well that you are a judge, and she still doesn't resign from PRASA. She waits until the 16th of March to resign from PRASA. So President Japie, I've taken the court briefly to these facts because I think they're important. The legal argument shows that this debate about employment is wrong, but the facts show that Judge Makhubele never believed it at the time. So that's not the reason why she acted as she did, because she thought, well, this is an employment relationship and I'm still waiting for the acceptance of my counteroffer. That wasn't how she saw the position at the time. So it can't be a sort of excuse of, even if I was wrong on the law, I thought I wasn't a judge. That's not consistent with the facts. And the final point that's important is that the fact that this argument is advanced by Judge Makhubele to this tribunal is concerning, because the cases I've taken to show that the idea that a judge is an employee is fundamentally inconsistent with the judicial independence. But Judge Makhubele is advancing it here as a way to justify her conduct, which was itself inconsistent with judicial independence and the separation of powers. So that deals with the first defense, which is the employment contract defense. The second defense is this sort of two different ways that the Judge Makhubele tries to deal with J.P. Mlambo's evidence. The one is to say the inconsistencies are only minor, they're not major, and the other one is to say that there's no real conflict. Also, so the first is to say that the differences are inconsequential, and the second is to say, well, we can reconcile the two versions. They're sort of different ways of making the same argument. But both of them are wrong because the differences are clearly consequential. And I've made this argument already, but just to sum it up, if this tribunal accepted Judge Makhubele's testimony, that she had an agreement with Judge Mlambo before the JSC she'd start in April 2018, that it was confirmed in December 2017 that she'd start in April 2018, then it shouldn't find her guilty of gross misconduct. But if this tribunal accepts J.P. Mlambo's testimony, supported by DJP Ledwaba, that wasn't the case. There was no agreement between him and Judge Makhubele that she would start on any date other than the 1st of January, that she was called in the middle of January, asked to take the oath and refused, then she is guilty of gross misconduct. So the differences are not just consequential, they're determinative of the outcome. So they can't be waved away. What the Judge Makhubele's counsel tries to say, oh, well, there's a lot of agreement that, well, there were discussions and there was a debate about starting dates, and so they're all kind of on the same page. They're not on the same page on what really matters. On what really matters about whether there was an agreement prior to 1 January and whether the mid-January meeting happened, there's only stark disagreement.
The meeting in mid-January for the case against Judge Makhubele is whether that meeting in mid-January 2018 in fact happened.
Yes.
Because if it happened, it explains the conduct before.
Yes.
That. If it didn't happen, then all of Judge President Mlambo's evidence is manufactured.
Yes.
That's the choice that we have on that meeting, isn't it?
Yes.
Yes.
And unfortunately, as Mr. Paver said as well, it's not one of those cases where sometimes a court or tribunal would prefer not to make a finding that one or other witness has misled it. But it cannot avoid it in this case, because whether the meeting occurred or not determines the outcome that this tribunal must reach.
On the first count, let's
Yeah,
call
on
it.
the first
complaint, if I may call it that.
Yes.
Yes,
Yes, and the version, it's not a situation where Judge Makhubele came and said, I don't recall whether there was a meeting in mid-January, I don't remember it, I'm not sure, or there was some minor disagreement about exactly what was said at the meeting. She was very clear there was no meeting. I mean, the reference is in her testimony, it's Core Bundle Volume 16, pages 149 to 50, where Judge President Japie is asking her about the meeting, and she's very clear, no, there was no meeting. So again, Mr. Paver gave the example of an identity where someone can honestly believe they're telling the truth but be mistaken. This is not such a situation. One witness told the truth and one witness did not. There's also an attempt made to rely on the presumption of judicial integrity, that because of that, this tribunal should either accept Judge Makhubele's version or avoid trying to resolve the dispute. With respect, we don't understand that presumption applies when judges are witnesses. It applies to recusal applications. There's no reason why judges should be treated differently from other witnesses when they give testimony under oath. But in any event, how does the presumption apply? Because you've got a judge on both sides. You've got Judge Makhubele and you've got JP Mlambo. Who gets the presumption of integrity when they have mutually inconsistent versions? So ultimately, the court has to make a determination. I've given all the reasons in the head why it should prefer the version of Judge Mlambo. And once it does, that isn't fatal for Judge Makhubele. It's clearly gross misconduct because she was a judge and she refused to do her job because she wanted to work for the executive branch of government and she didn't want to disappoint the minister. So those are the submissions on Part A, or first complaint. My submissions on Part B will follow the same pattern. I'm going to give a summary of our case as we see it, and then deal with the defenses that have been put up by Judge Makhubele. And what is the complainant's case in a nutshell on the second complaint? Effectively, it's that Judge Makhubele misused her position as chairperson of PRASA to settle the CI claims, the CI litigation, when she had no authority to settle them. She was communicating throughout with CI's counsel without informing her attorneys or counsel or internal legal that she was communicating with Bertus. She did it without putting PRASA's lawyers in a position to advise her on whether to settle the claims or not. She intentionally excluded PRASA's internal lawyers from the decision on whether to settle or not. And she disregarded the clear advice that PRASA had strong defenses to each of the claims. She then worked with Bertus, or she enabled Bertus to prevent PRASA from stopping the applications to have the arbitration awards made orders of court. And all of this was contrary to her obligations as an executive director, non-executive director of PRASA as chair of the board under the PFMA. And it was contrary to her obligations as a judge, because the conduct extends not only in 2017, but into 2018. And I've already made the submission that she was a judge from the 1st of January 2018. And it's not each particular one, the fact that she didn't have authority on its own, or the fact that she excluded the legal team on its own. Each one of those, we don't say each one of those is on its own gross misconduct. We say you have to look at it together, you have to look at the pattern of how did she settle the CI litigation. And when one looks at it cumulatively, it's inconsistent with her obligations under the PFMA, and therefore it's gross misconduct. I will get to the argument when I deal with the defenses about this question of jurisdiction, and whether this tribunal has jurisdiction over conduct of somebody who is now a judge that was committed before they were a judge, and in a different capacity. So I will get to that argument when I deal with defenses. We submit that it does.
About Advocate Bertus SC, for what you're saying now, it means this tribunal must approach his evidence with caution. He took advantage of Judge Makhubele. There were extensive communications between the two of them, as we said before. And therefore his evidence cannot just be accepted like that. He took advantage, he was aware of it, he was senior counsel. I think somewhere Judge Makhubele testified that he abused her or something, and she ended up putting in a report with the Society of Advocates in Pretoria.
Yes.
So the question really is, as a tribunal, it means the evidence of Advocate Bertus must be approached with caution.
I think that's right, Judge Mashidi. I think there should be a degree of caution to Advocate Bertus's testimony for the reasons that you give. But the same time, I think on the key issues that matter, there's either documentary evidence to establish what occurred, there's communications, including WhatsApp communications between Judge Makhubele and Advocate Boertes, or there's no dispute about what occurred. So on the actual facts that matter, and the one big difference is who initiated the communication. That's where Judge Makhubele and Advocate Boertes really disagree strenuously about what happened. But for the rest of it, there isn't really, Judge Makhubele doesn't say Advocate Boertes was lying about the majority of what he testified on. But I accept that there must be some caution in assessing his evidence.
Well, what do you say, how did Judge Makhubele and Advocate Boertes then get together on the CIA matter?
Yes. President Japie, there's two versions. Boertes says that Judge Makhubele called him first. Judge Makhubele says that he called her first. It seems to me that it's not necessary or even really possible to resolve that dispute. But despite the investigation that was done in the Zondo Commission, looking at their phones, it's not possible from that to say conclusively that there wasn't a call, for example, from a landline to Judge Boertes' telephone before he called Judge Makhubele. So it's not conclusive. I don't think it's possible on the evidence before this tribunal to determine conclusively who called who first. And I think while it would make arguably Judge Makhubele's conduct worse if she initiated it, what happened subsequently still amounts to gross misconduct. So I don't think it's necessary for the tribunal to resolve it, and I'm not sure how it does. So I want to go briefly, thematically, through what we say are the major, the ways in which Judge Makhubele violated her obligations to PRASA under the PFMA. The first is that she acted without authority. And we detail this in the heads. I'm not going to take the court in detail to the delegations, but we've taken them out exactly what each of the delegations, whether it was the Molefe one or the Buthelezi one, under neither of them did either Judge Makhubele or Mr. Zide have the authority to settle these claims unless they had a report from Ms. Ngoya. So it depends, the requirements differ, and it's different for different claims, because it's not one claim, there were 4 claims of different values, some under 10 million, some over 10 million, and the requirements are slightly different. But there is no way under either of those delegations that these claims could have been settled in the way that they were. And so that's the fundamental point, is that Judge Makhubele acted contrary to the delegations of authority for the board she was chairing. There is a claim that she was not doing this, that she wasn't settling the claims herself, she was merely assisting Mr. Zide, who was the AG CEO at the time. We submit that that claim is not plausible. Mr. Paber dealt with it, but there's no documentary evidence to support it. There's a very convenient, secret in-committee meeting of the board, which has no minutes and no recording, where this decision was supposedly taken, but there's no record of it anywhere. There's no email that supports it. There's absolutely nothing to suggest that the board took this decision. It's entirely inconsistent with the evidence of Mokhashwa, and the point was never point to Mokhashwa. And it's inconsistent with Zide's letter to Mokhashwa on the 15th of December, and it's inconsistent with the subsequent communication, including the letter that Judge Makhubele writes, where she talks about her decision. So, but anyway, it still doesn't matter for the question of the authority under the delegations. Judge Makhubele didn't have the authority herself, and she still didn't have the authority even if she was working together with Mr. Zide to settle these claims. So she acted without authority.
Well, if you agree with the evidence that that board at the time was not correct,
yes.
So do your argument falls away?
Well,
in any case, no board. It was not correct.
I suppose so, but I think that again makes it worse for Judge Makhubele, because at the meeting of 1 December 2017, where it's raised that this board is not correct, what Judge Makhubele says effectively is she doesn't conclude whether it's correct or not correct. She says that's a problem for the minister, who's the appointing authority. Because remember, the problem was there was no person who had been appointed from the Department of, or from National Treasury. And she says, well, I can't appoint someone for National Treasury, that's for the minister. But that doesn't deal with the problem of coercy. You're still in corate, even if it's not your fault that somebody hasn't been appointed who needs to be there. And she still proceeds with a meeting where they take very consequential decisions, including disbanding the legal panel, without concluding whether or not this board is corate and has the power to do anything. So I'm not sure that, I think the incoracy acts against Judge Makhubele. It's not a point we place much value on, but I don't think it helps her cause.
But don't we have a judgment from Cape Province that at that stage that board was not properly constituted?
There was an application brought by my client, by hashtag Unite Behind, but there was never a judgment. That the application was never finalized.
But wasn't the minister instructed to constitute a board? Unless we talk about two judgments.
Oh, there was a judgment, but it came long afterwards, I'm advised. Yes.
But as to whether the board that Judge Makhubele sat on, what is your submission, whether it was corate or not?
It was not corate because, as the Auditor General had pointed out, it didn't have a representative of National Treasury. And the Act required a representative from National Treasury.
Now let's then deal with the consequences. If it wasn't corate, could the board then take the decisions, which it did, in regard to the settlement with CIA?
No. But even if it was corate, it could, yes. Yes. Yes.
If it was not corate, then the board could not have taken the decision.
That's correct.
That is one submission. Now you wanted to say, let's put that submission aside. Let's look at what actually happened. That's the point of the argument that you now want to advance.
Yes.
Yes, well, let's go there then.
Yes. So even if it was corate, it didn't in fact ever take a decision to ask Judge Makhubele to settle the CIA claims. And in any event, it couldn't because it would have been inconsistent with the delegations of authority. And there's no evidence of any such decision ever having been taken. So the first theme is the lack of authority. The second theme is her relationship with Advocate Boertes. And I've dealt with this already to some extent. But it's important to look, it starts in mid-November 2017 and continues all the way through this process. Their testimony is that they were WhatsApping between it. Up until 2018, there's WhatsApps, which I'll take the tribunal to shortly, that about trying to arrange the payment after the settlement on the 24th and 25th of January 2018. And up until March, when the application before Holland Mutter AJ. So throughout this process, Judge Makhubele is communicating with the senior counsel for CIA, and that on its own is certainly problematic. But she never tells her attorney, her counsel, her internal legal advisors that this is what she's doing. She's doing it entirely separately without anybody knowing that she's doing it. And that may be ethical if you are an advocate. Advocates often have communications with advocates on the other side to try and move a case forward or try and resolve a case or settle a case. That happens every day. But Judge Makhubele was not an advocate at that moment. She was the chairperson of the Board of Control of PRASA. And she was the client, not the counsel. And that type of communication where you are in a position of trust towards PRASA and you're secretly communicating with counsel for a company that's suing you for millions of rands, that is improper. The next theme is the failure to provide the 417 report or the Krige report. And this is really difficult to understand because multiple requests are made. We set it out in, I won't take the tribunal there, but it's paragraph 239 of the heads, where we give the references for the requests in the memo from Mogashwa, the memo from Dingaswayo, where they say in writing, please give us the report so we can give you better advice. Because you write this memo on the 28th of November, where you say these major concessions have been made in this report. but you never provide them with the report. And Mr. Tintswalo, he wasn't at the tribunal, at the 417 inquiry. Mr. Mukhasha was there, but his testimony is it seems he wasn't paying a huge amount of attention to what was going on. But Mr. Tintswalo wasn't even there. How could he meaningfully respond to these supposed major concessions where he's never provided with the report in which these are recorded? And Judge Makhubele's testimony that nobody ever asked for the report is simply inconsistent with the contemporaneous documents, because those documents expressly ask for the report. It was also the testimony of Mr. Mukhasha and Mr. Tintswalo and Martha Ngoye that they asked for the report, and it was never provided.
But was there no reason given by Judge Makhubele for not giving or making the report available? She did advance a reason.
She said that the report was given to her in confidence by
A colleague.
sorry. Yes. She said it, sorry, not confidence, in collegiality by Advocate Boertus. But that's no reason not to provide it and then to take a decision where Mr. Tintswalo, Ms. Mokateri, Mr. Mukhasha, Advocate Tsatsawane had been working on this case for years. And then you're taking a decision to settle these various cases based on this report, which you've never provided to the people who've been working on these cases, who drafted the pleas, who are steeped in the history of the case, who know all the evidence. And you're going to take a decision based on this report, but you never give it to them to give so they can advise you properly. That, with respect, is not only procedurally irrational if we're talking in a public law sense, but it's contrary to the conduct expected of executive or non-executive directors, any director of a state-owned company.
Sorry, just to remind me, was Advocate Tsatsawane not at the inquiry?
He
on
was
behalf of PRASA.
He was at the inquiry, yes. But it seems that there's an absence of evidence of this, but there's no indication that his advice was ever sought after the inquiry about this question of settlement. But yes, he was present at the inquiry. So the next theme is that Judge Makhubele sidelined the internal PRASA legal team, so particularly Mr. Tintswalo, Ms. Ngoye, Ms. Mokateri, and so it's from after the board meeting on the 1st of December, so she does ask for their opinions up to then, and they, Mr. Tintswalo advises her that they should not settle these claims, that PRASA has good defenses. And thereafter, from the 4th of December, when Judge Makhubele meets with Mr. Mukhasha, Mr. Tintswalo is not included. Ms. Mokateri is not included. They're not invited to the meeting on the 14th of December. They're not invited to, Judge Makhubele testified that between the 4th and the 14th of December, the 15th of December, sorry, she interviewed or consulted with various employees within PRASA who had knowledge of these cases. Internal legal is not invited to any of those. Internal legal is not copied on the letter that Mr. Zide sends to Mr. Mukhasha. They're not copied on any of the correspondence that happens thereafter when the settlements are reached. And so it's clear that they were intentionally excluded from the settlement process. And there's no good reason for that. Again, Judge Makhubele, denied that they were excluded. But if one looks at what happened, who was at the various meetings, who was included on the correspondence, they clearly were excluded. They were cut out. And they were not involved in the settlement. And the consequence of all this, of speaking to Advocate Boertus, of not giving your advisors the Kricher report, of cutting them out of the decisions to settle, is that the decision to settle, ultimately Judge Makhubele couldn't have been in a good position to take the decision. And the decision she took is substantively unjustifiable. So I don't want to bore the tribunal by going through each of the cases and the pleas. I won't do that, but we have done the work in the heads of argument. We attach a table to the heads of argument where we go through each of the 4 cases, what the claims were, what the defenses were, and what was said at the inquiry, and show that what was said at the inquiry does not undermine the defenses. Because the defenses were various varieties of the contract was invalid, the variation was invalid, the work was done, but it wasn't what was contracted for, or you didn't do the work that was contracted for. The defense is never, there was no contract or no work was done. That's not the defenses. The defenses are more subtle than that. But they're still good defenses in law. And what's said by the witnesses at the inquiry does not undermine those defenses when you look at it. And so that's what Judge Makhubele would have discovered if you put her legal advisors in a position to advise her. She shouldn't have been involved in this at all. This should never have been on the chairperson's desk. This should have been dealt with by Mr. Tintswalo and Ms. Ngoya, because these were relatively small claims in the scheme of PRASA. They were claims of between 7 million and I think the largest was 17 million. These are not massive claims as far as PRASA is concerned. But even if Judge Makhubele was going to be involved as the chairperson, she would have realized that there are defenses to at least parts of these claims, but that she settles the full amounts with interest. And that was not a rational decision. It was not a decision taken in the interest of PRASA. As Mr. Paba pointed out, there was no rush. There was no need for this decision to be taken urgently before the holiday season commenced. There was no rush from PRASA's point of view. So that's the next theme, is that even after the settlement is made, Judge Makhubele continues to work to secure the payment. So that starts with the email that she sends to Mr. Zide just after the settlement is concluded. I think it's on the 21st or the 22nd of December, where she says, please, I want to get the wording correct, but I think she says, please proceed with regard to payment. So she instructs Mr. Zide. But then there's difficulties in January, because Ms. Page, the CFO, is unwilling to make the payments because she can't get sign-off from Mr. Tintswalo or Ms. Ngoya. They say we don't know anything about it. And she can't get sign-off from the CEOs for those units. And then there's very interesting WhatsApp discussions between Judge Makhubele and Advocate Boertes on the 24th and 25th of January 2018. And these are contained in volume, sorry, what Judge Makhubele says on the 21st of December is, to Mr. Zide, please attend to finalize the matter with respect to payment. This has now been settled, but she also wants him to ensure the monies are paid. But, so to come back to the WhatsApps, they're contained in Core Bundle Volume 18. These are WhatsApp that were provided by Judge Makhubele to the tribunal. They start at page 186. And what they say is, so first, Advocate Boertes had written a WhatsApp asking for, is there going to be payment? And then Judge Makhubele writes back, he says, Dear Francois, my quietness is caused by shock and disgust at the open defiance of the finance lady. There are rumors and insinuations of wrongdoings doing the rounds, but I'm waiting for a written confirmation of exactly what the problem is regards wrongdoing on my part. Then Advocate Boertes writes back and says, thank you for the update. You were treated with the utmost disrespect and gross insubordination. Her conduct is tantamount to contempt, and she is undermining your authority as chairperson of the board. Your integrity is above suspicion and beyond any doubt whatsoever, and we appreciate your valuable input and unselfish contribution to dispense justice. That's what Advocate Boertes says to Judge Makhubele. Then Judge Makhubele responds, thanks for the confidence, Francois. I just had a meeting with the AG CEO about it. So this is about the CIA claims and the payment. It is part of the smear campaign that's playing out in the media and the High Court matter at Western Cape High Court. Zide and I have followed a due process, and I applied my mind properly. The legal section is the one pulling the finance strings by telling the lady that they were preparing to fight the case and pay zero, and they distance themselves from the settlement. Of course, part of the campaign is about the resolve of some individuals. Within that, the owner of the companies is deemed to have committed some criminal deeds. To them, it doesn't matter whether the contract is tainted or not. On the bright side, it looks like we may have a breakthrough. I will update you tomorrow. I'm prepared to fight for my good name. And Advocate Boertes responds, Dear Nana, just for the record and for your peace of mind, the settlements talks about the company in liquidation, not the creditors. Mr. Mackenzie Mabunda was the director of the companies in liquidation. The amounts which form part and parcel of the settlements are paid into the trust account of an independent attorney and not into Mr. Mabunda's account. Remember, Mr. Mabunda's name also comes up in the Worksman's report. He's alleged to have been involved in corrupt activities with regard to other contracts with PRASA. That's why Mr. Mabunda's name is raised. And then on the 25th, Judge Makhubele writes to Advocate Boertes, "We had a long meeting with the finance lady. There's a clear way forward. Zida and Madimpe will attend to the outstanding issues on the submission for payment. Just arrived home and I'm emotionally drained, resting. Call me tomorrow morning for specifics." So through January, Judge Makhubele is working within PRASA to try and get this money paid, the money that she had settled a month earlier. She's having meetings with the AG CEO, with the CFO, to try and unlock this payment, because she's invested in ensuring not only that there was a settlement, but the money is now paid to the CIO companies. So the claim that she had no interest in payment is false. It's belied by these WhatsApps. And then the final part of her misconduct relates to what occurred in front of, in the applications that came before Holland Mutter AJ. And the tribunal knows this, that Advocate Boertes writes to Judge Makhubele to say, "I see that Bowman's is now defending this on behalf of PRASA," and she writes back, I think it's by SMS or WhatsApp, writes back to him and say, "Bowman's can have no authority because they're not on the panel. We're now using because the panel was disbanded, we're now using the SACA panel." And Judge Makhubele was upset that Advocate Boertes then uses that communication in order to prevent PRASA from even defending the applications. But what did she expect was going to happen? You provide this information to the senior counsel for an applicant, and you tell them, as chair of the board, that these attorneys have no authority. What do you think the advocate is going to do? He's going to use that information for his client's advantage, because that's what advocates do. And that results in, as Mr. Paver pointed out, bank accounts being attached, the further costs of the rescission application, all because of this ongoing improper communication with Advocate Boertes. So what do we make of all of this, all this conduct over the period from November 2017 all the way through to March 2018? And simply, it is not the conduct of a chairperson who's acting in the best interests of PRASA. It seems that she stepped away from the ordinary role of a chairperson. A chairperson is not meant to be involved in the day-to-day running of a company, to be settling relatively small claims, and to be getting her hands dirty in this way. She went into the details of this particular claim and settled it without authority, without the necessary information, contrary to advice, and while communicating with the advocate for the other side. And we submit that there's two explanations for this conduct. The one is that she was acting with an ulterior and impermissible purpose, that she was intentionally trying to get this money out of PRASA. And the other explanation is that she was acting with reckless disregard for the interests of PRASA, that she was acting for whatever the motivation had been, but it wasn't in the best interests of PRASA. And the criticism is made that there's no evidence of corruption. There's no evidence that Judge Makhubele received a payment from CIA for this conduct, and that's true. There is no such evidence. There's no evidence that Judge Makhubele received any payment or consideration for this. But her conduct remains inexplicable other than an improper purpose or reckless disregard. And this tribunal doesn't have to decide which is true, because either way, it's gross misconduct that requires her removal as a judge. Because whether she was doing it for an improper purpose or merely because she acted in a manner that was so negligent and reckless that it could have cost PRASA 55 million rand, either way, she's not fit to be a judge.
So you mean that, Mr. Bishop, we should also speculate as a tribunal?
I don't think you need to speculate, Judge Mashida, and I think it would be inappropriate for the tribunal to speculate. I think what matters more than Judge Makhubele's motivations is her conduct. So was the conduct that I've described, that Mr. Paver described this morning, was that conduct the conduct of a person who's demonstrated the attributes that are required of a judicial officer? Or is it the conduct of a person who's demonstrated that they lack the requisite character to be a judicial officer, whatever the underlying motivation or explanation may be for that conduct?
I just don't quite understand that submission that you've made over there. When you attack the character of Judge Makhubele, what do you mean? Can you just perhaps elaborate on that?
Yes. What the evidence shows is that Judge Makhubele was willing to settle these claims in a manner that was improper. So what, she acted without authority. She communicated improperly with Advocate Burtis. She excluded her own legal team. She never put them in a position to take the decision. She took further steps after settlement to ensure payment, all which was not part of her job as chairperson. And we submit that there are two possible explanations for why she acted that way. I don't know why she acted that way. Because her testimony was that she did nothing wrong. She never said, I accept I did something wrong and this is why. She said, I acted perfectly throughout. And if this tribunal disagrees with that assessment and concludes that Judge Makhubele, that this conduct was not acceptable conduct for a chairperson of PRASA, it can either try and decide why she acted that way, or what we submit is it doesn't need to decide that. It has to decide whatever the explanation. Somebody who acts this way when in that position of fiduciary obligation towards an organ of state has shown that they're not the type of person in whom the public can have confidence to perform as a judge, which is the test for gross misconduct. So,
I may just get the argument. Judge Makhubele was in a position where she had to discharge whatever function towards PRASA with a fiduciary duty.
yes,
You say her conduct in the circumstances of this case shows that she didn't exercise this fiduciary duty. Is that it?
yes, and the specific fiduciary duties under the PFMA.
Yeah, no.
Yes, that is the argument.
That is the argument.
Yes,
And because she didn't exercise her position with these fiduciary duties is an indication, you submit, of gross misconduct in the circumstances of this case.
that's correct. And the fiduciary obligations that she had were the obligations, this is in paragraphs 305 to 7 of the heads where we list the sections, but just briefly, to act in the best interests of PRASA, to avoid fruitless and wasteful expenditure, and to prevent expenditure not complying with operational policies of the public entity. And those are all obligations that were breached in this case. And that conduct is also contrary to the code. It's contrary to Article 5, because it acted in a manner that, Judge Makhubele did not act in a manner that enhances respect for the judiciary. It's contrary to Article 6, because a judge must at all times, also in relation to extrajudicial conduct, comply with the law of the land. And these violations of these fiduciary obligations are criminal offenses. They're not just general guidelines. They're criminal offenses if you don't comply with them. So that's our case. You summed it up well, President Japie. In the, I assume we're going to finish at 4, and if I should be done by then.
You.
No, I think I'll be done by 4, President Japie.
Well, you got
In 12
10
minutes.
Yes.
I just need to deal with the defenses that were raised in the heads of argument. And the primary one that's raised is really a technical defense about the jurisdiction of this tribunal. So the argument is this tribunal does not have jurisdiction to consider conduct by Judge Makhubele that A, occurred before she was a judge, and B, occurred when she was the chairperson of PRASA and not a judge. And we submit that that argument should fail for 3 reasons. The first is that the conduct extended from when she was not a judge over into when she was a judge. I made the submission earlier that she was a judge on the 1st of January 2018. And some of the conduct occurred beforehand, the settlement occurred in December, but then the attempts to force payment and the interference with the defense all occurred in 2018 when she was a judge. And so, one, the tribunal clearly has jurisdiction over what occurred in 2018, And it would be artificial to separate the two, to say we're going to look only at 2018 and ignore what led to what occurred in 2018. So that's the first reason. The second reason is that this tribunal does have jurisdiction to look at conduct of judges before their appointment date. And I accept it may be difficult at some point to draw the line of how far back can you go when you're looking at judicial misconduct, but this is an easy case. Because if one looks at the timing here, everything happens after the JSC advises the president to appoint her. So normally what would happen when you're up for judicial appointment is before the JSC, if there's any skeletons in your cupboard, they will come out in the JSC. And people will complain, or if there's evidence of prior disciplinary proceedings against you, that will be put before the JSC, and the JSC will evaluate it and decide what to make of it. But it doesn't, there's always a period of a few months between the JSC interview and the appointment process. It cannot be that you now have a free pass to do whatever unethical conduct you wish in those few months. And it can't be brought up in your interview because you already had the interview, and you can't be brought before a Judicial Conduct Tribunal for it because, well, I wasn't a judge. So from that moment when you are, the JSC advises that you advise the president to appoint you, you're not a judge in the formal sense. She was a judge on the 1st of January. But her conduct during that period can be looked at by a Judicial Conduct Tribunal because it's the only way to protect the integrity of the judiciary. Otherwise, if this type of technical argument would succeed, you can engage in any type of conduct you like. And there is precedent as well for Judicial Conduct Tribunals looking even further back, looking into the conduct of judges when they held positions of trust, particularly the Judge Parker JCTE. So the Judicial Conduct Committee met. One of the complaints concerned interactions with the Judge President, but the second one concerned whether Judge Parker had misled the JSC in his interview, but also whether he had effectively withheld money in his trust account, and whether he and his partners had taken that money. And that all occurred when he was an attorney, before he was a judge, before even his interview. But the JCC recommended that it went to the JCT. That tribunal hasn't happened yet. But again, one can see from fundamentally the purpose of these misconduct proceedings are to protect the independence, integrity, dignity of the courts. And if it could come out after somebody has been appointed as a judge that a few years ago, they stole money as an attorney, but, oh well, there's nothing we can do about it, they've been appointed already. That would not serve the purpose of the power that the JSC has to investigate into misconduct. Because what it ultimately reveals when we're talking about gross misconduct, and this comes back to the definition I gave right at the beginning, is it conduct which would diminish public confidence in the judiciary or diminish the confidence of a litigant who came before this judge? So we submit that this is an easy case because it's concerned with a small window period where surely aspirant judges or people who are soon to be judges cannot be given a free pass. But in addition, judicial conduct tribunals can look back, particularly for conduct such as this dishonest conduct or conduct that's inconsistent with fiduciary obligations, whether that's a chairperson or an attorney. So we submit that that this tribunal does have jurisdiction. That brings me, the final defense relates to the merits. And there's two types of defenses. The first one is really a straw man argument, which in the main heads of argument, Judge Makhubele's counsel sort of goes through each of the items in the terms of reference. So let's say that Judge Makhubele acted without authority, that it was a secret settlement. The tribunal knows the terms of reference, and looks at each of them in isolation. It says, if one looks at each of these in isolation, how could that be gross misconduct? But that's never been the complaint. The complaint has never been that there are 6 different counts of gross misconduct. The complaint has always been, look at the conduct cumulatively, and that constitutes gross misconduct. So that's not a defense to the actual complaint. In the supplementary heads, there are a range of defenses. I counted 12, where various points are taken about the evidence that was led. I'm not going to go through all of them, but I just want to go through some of them quickly, just to let the tribunal know what the answer is. the first point that's taken is that there's no evidence of corruption, and I conceded earlier that that's correct, but that's not our case. Our case is that we don't have to prove corruption to prove gross misconduct. The second is that it's not possible to say that Judge Makhubele focused only on the CIA cases. That's part of the terms of reference. And the point is made, well, no audit has been done of all the other cases that Judge Makhubele was involved in to show how much time she spent on those relative to the CIA cases. But it seems that that's not necessary to show that she's paid special attention to the CIA cases, because what we know from her own version is that Judge Makhubele became particularly involved in the CIA cases. She was communicating with opposing counsel, she was interviewing employees, she was involved directly in settlement negotiations, she was ensuring payment was made, and no other case, Judge Makhubele didn't identify any other piece of litigation where she took that active operational role in the litigation. So it has been proven that she's paid special attention to CIA, because it's the only piece of litigation we're aware of where she behaved in the way that she did. The third issue relates to the terminating of the mandate of attorneys. We mentioned this in the heads of argument that it seems to be a misunderstanding by the JSC about the nature of the complaint. The complaint related to the abolition of the legal panel at the 1 December meeting. There was never an allegation by the complainant that Judge Makhubele fired Mr. Mukhashwa and appointed somebody else. So that was just a confusion, I think, in the way the JSC formulated the terms of reference. The fourth claim is that, which I've dealt with already, but this is in the supplementary submissions at paragraph 33, where Judge Makhubele argues that it wasn't her that settled the claim, she was merely assisting Mr. Zide. And Mr. Paver has gone through that, I've gone through that. That's just not consistent with the evidence. It's clear that it was, in fact, Judge Makhubele who was the animating force behind the settlement. The fifth argument she makes is that Judge Makhubele did not exclude the legal team and that it wasn't a secret settlement. There's been lots of sort of dancing on the head of a pin about what secret means, because the word secret is used in the terms of reference, that it was a secret settlement. And what is meant by that and what was established is that the legal team was excluded from the settlement. So Mr. Dingaswayo, Ms. Ngoya, Ms. Mokatedi were not involved in the settlement. And that's particularly clear from an email that Mr. Dingaswayo sent on the 18th of January. It's in Core Bundle, Volume 11, page 84. And so this is an email, so Ms. Rose Monyosa sends Mr. Dingaswayo an email on the 16th of January saying, "Morning, Fani, I'm looking for the invoices for Siaya, for actual work done that are in the arbitration attached. I've received the attached documents from Yvonne. The actual invoices are not attached." Then Mr. Dingaswayo responds as follows. "Good afternoon, Rose. The matters of Siaya were handled by Group Legal Services and we were preparing ourselves for an arbitration as we believed that we had good prospects of success. When the board was appointed, the chairperson of the board indicated to us that she had some knowledge of the matter and indicated that she would from that point on handle the matter herself and communicate it to the lawyers herself. The chairperson has not shared the information that was in her possession with us. We were therefore excluded from the matter and believe that we are barred from dealing with the matter as we held a view that was different from the chairperson of prospects of success of the matter." So this is contemporaneous correspondence from Mr. Dingaswayo at the time, the 18th of January 2018, that records at least what he understood the position to be. And it's consistent with the fact that none of them are present at any of these meetings or copied in any of the correspondence. So in that sense, it clearly was a secret settlement. So there's an argument was made that the memo from the two memos from Mr. Mukhashwa shouldn't be given any weight because he admitted that he never consulted directly with the relevant employees. And that's true, he did say that in his testimony, but the reason is, and Mr. Dingaswayo explained this in his testimony, is that the way it worked is Group Legal effectively saw the different units within PRASA as their clients. So they would consult with the clients and then they would pass the instructions on to the attorneys. So it would be Ms. Mokatedi, Mr. Dingaswayo who were consulting with Mr. Balfak, Mr. Kobuye, Mr. Vermeulen, and they would then pass the instructions on to the attorney. That's how it worked in PRASA. And Mr. Dingaswayo explains that in Core Bundle, Volume 10, pages 7 to 8. There's also a claim, which is advanced still in the supplementary submissions, that there's no evidence that Judge Makhubele withheld the Section 417 report. And I've dealt with this already, but the evidence is clear. It's documentary evidence. It's not just the testimony of Mr. Mokhashwa and Mr. Tintswalo. It's in the memos at the time which say, please give us a copy. And that the final argument that's advanced is that, all of this happened because the legal unit was not prepared to cooperate with the board. And the legal unit was being obstructive and obstreperous, and that's why Judge Makhubele had to take over. The only example that's given in the supplementary submissions relates to the legal panel. So the tribunal will recall that on the 1st of December 2017, the board took a decision to suspend the existing legal panel and say from henceforth you should have a procurement process. And then on the 4th of December, Ms. Ngoya and Mr. Tintswalo write to the board, so the 5th of December, they write to the board and they say a memo dealing with various things, and a very, quite a detailed memo where they explain what the difficulties will be encountered from this decision. And I would invite the tribunal to go and reread that memo. It's Core Bundle Volume 9, pages 149 to 155. And it's incredibly respectful, constructive memo. What they're saying is, I'm not sure you've thought through what the consequences of your decision are. I just want to tell you that this is going to cause a lot of problems for PRASA. We think maybe you want to reconsider your decision. It's not insubordinate. It's not obstructive. It's constructive. And they said then we'd be happy to meet with you to discuss. And there was no response. President Japie, I'm about to conclude, but just one small submission that I've neglected to make. You will recall that when Judge Makhubele sent her memo of the 28th of November asking for a response from Mr. Tintswalo and from Mule and Baltek and Kubuya, that a response was also given by Mr. Mokhashwa, where he sets out what his views are. And Judge Makhubele is upset by this and effectively disregards the memo because she said, I never asked for this memo from the attorneys, I only wanted it from internal legal. But again, it may be that you didn't ask for it, but you've received it. You've got this information from a person who was present at the inquiry, who's been involved in the reports, and you just close your eyes to it and say, I'm not going to look at it. And it's a strange sort of seeing disrespect where there is no disrespect. Because no disrespect is meant by passing it on to the attorneys. They're trying to help Judge Makhubele to understand what's going on in the litigation. And she says, I don't want your help. I don't want to know what you have to say. I'm not going to look at it because I feel in some way offended by the fact that you prepared this memorandum at all. And that's indicative of her attitude throughout. So, President, in conclusion, we submit that the tribunal has jurisdiction for this claim and that litigants and the public in general cannot have confidence that a person who acted the way Judge Makhubele did as chairperson will fairly evaluate their litigation as a judge of the High Court. So may I just quickly speak to my juniors? My learned junior has just a question that you asked President Japie, going back to Part A briefly, about whether the President has the power to issue a new certificate of appointment for a different date. And the answer to that is, if one looks at the Constitution, effectively what that does is it removes a judge from their position. But the Constitution sets out the process by which a judge is removed. And the only way you can remove a judge is on a finding of the JSC sent to the National Assembly. And that's effectively what the President would be doing, so it would be unlawful. But again, my primary submission is the tribunal doesn't need to decide the point, that legal point.
Thank you.
Yeah. Thank you,
Mr. Masuku, tomorrow morning, does that suit you? What time?
I'm raring to go now if the tribunal is, waiting until tomorrow is a bit too much. No, tomorrow morning is fine. Yeah, 10 o'clock is fine, Judge. Thank you. Yeah, hold on. You should let me go and then just deal with this thing,